Well, good afternoon, everyone. It is now 5:15. Thank you all for joining this afternoon's event, GLR event webinar. My name is Thanos Moros, and I'm the GLR event coordinator. Today we have Robert Rayner, who will talk to us on patents for beginners, a practical introduction to the British and European patent application. Robert will be joined by his colleague and associate Andrew Mackenzie during the Q&A session. Because this is a webinar, you all be muted during the presentation, and please ask questions using the box, the right-hand side, right at the bottom, which says Q&A. Type your question there, and it will be addressed during the Q&A timing. There are two boxes. One is the chat one and the Q&A. Please avoid using the chat box and put all your questions in the Q&A box. I will now pass on to Robert and Andrew to introduce themselves. Over to you.
Okay, should I go first? Hello, everybody. My name is Dr. Robert Rayner. I'm the Deputy Head of Mathematics at St Columba's College in St Albans in Hertfordshire. And I'm also a part-qualified patent attorney. So we're going to be talking to you today. The title of today's presentation is Patents for Engineers. So I have a strong background in mechanical engineering, having got a master's degree and PhD degree in mechanical engineering, and I've also formerly worked at Kingston University, London, where I was a senior lecturer and course director in mechanical engineering, and I've also lectured extensively on intellectual property as well. So that's me. Andrew.
Thanks, Robert. I'm Andrew Mackenzie. I'm a patent attorney and a partner at the Cleveland Scott York. I have an engineering background and started my working career as an engineer at what was then Jaguar Cars Limited, and then retrained as a patent attorney, and tend to work in the sort of mechanical and automotive fields, but in the intellectual property arena rather than pure engineering these days. Okay, over to you, Robert.
Okay, right, so let's make a start. So if I do this. Okay, so right, let's make a start. Right, like I said, my name is Dr. Robert Rayner. I'm the Deputy Head of Mathematics at St Columba's College, and the title of today's presentation is Patents for Engineers, a practical guide to the British and European patent system. Now, before I start, I'd like to put a bit of a disclaimer on today's presentation. Now, today's presentation, obviously, we're going to be talking about legal and commercial matters, but I would urge you, please, not to use today's presentation as a sole source for definitive legal and commercial choices. If you do need to search for such information, I urge you, please, to go and seek the advice of a fully qualified legal professional who will be happy to take the time to chat with you and to give you the best possible advice on how to take your company forwards. Obviously, we hope that you find today's presentation informative and enjoyable. So, before I start, I'd also like to say a big thank you to Andrew Mackenzie for helping us put together this presentation today. Andrew has already introduced himself, so you know all about him already, but his firm Cleveland Scott York and Andrew both come with rave reviews from the legal press. Cleveland Scott York is a large and well-established multinational intellectual property law firm with offices in the City of London, Hertfordshire, Thames Valley, Munich, and Brussels. Andrew is also going to be helping us out with the Q&A session at the end of this presentation. So thank you very much indeed, Andrew. So what are we going to be talking about today? Well, today we're going to be talking about the following things. But first, we're going to answer the question, what is a patent attorney? What is a patent? And then we're also going to be looking at some of the benefits of patents. Why would you want one in the first place? Then we're going to talk a little bit about the history of the British patent system, and then talk about the patent application system, including talking about some of the requirements for patentability. Now, before I go on, I'd like to talk a little bit about myself and about my background. And there's a reason why we want to do this. This all kind of fit into the story. Okay, so currently I work as the Deputy Head of Mathematics at St Columba's College in St Albans in Hertfordshire. Now, St Columba's College, it's a Catholic independent day school for pupils aged between 4 to 18. And from its humble beginnings in 1939, St Columba's has grown to be a thriving school with over 800 pupils in it. And incidentally, it was also where I went to school as well. And in a staggering piece of coincidence, and we didn't know this before we knew each other, but Andrew's son also went to St Columba's College. But we didn't know this at the time, but so there's a nice bit of continuity there. Also looking at the attendance list, I can see some of my boys from St Columba's in the audience as well. So if you're out there, hello boys. Now, prior to working at St Columba's College, my background was very much in the realm of mechanical engineering. So you can see I've got a master's and a PhD, both in mechanical engineering. I have worked as a research fellow doing mechanical engineering research. I've also worked as a senior lecturer and course director at Kingston University, London, in the subject of mechanical engineering. I'm also a chartered engineer and a member of the Institution of Mechanical Engineers. So you can't really get much more mechanical engineering-y than that, really. For a period during my career, I also worked for an intellectual property law firm. In fact, it was an intellectual property law firm run and managed by Andrew. This is how we got to know each other. And during this time, I worked and trained to be a patent attorney. Now, doing this job, I learned a lot of things. And I became very aware of how the patent system works. I became very aware of how beneficial a patent can be to a patent holder and the great advantage a patent can bring a company in the marketplace. I also became very aware how misunderstood patents sometimes are by engineers. And I also became very aware of how nervous some engineers are to engage with the patent system. Now, in fairness, I can kind of understand why. The world of patents is one of lawyers and contracts and law courts, and it's quite a far cry from the normal place where engineers usually work. You know, CAD terminals and design studios and things like that. Okay, so we can clearly see there's a bit of a gap, a bit of a distance between the world of, how to say, normal industrial engineering and intellectual property law. In fairness, I don't think this gap should exist, and I think that the two trades, if I can put it that way, should exist hand in hand. And intellectual property law and patents should form an integral part of any engineering project in the way that maybe product design and market analysis does. Now, as with any engineering project, if there is an aspect of the project where you need some specialist help and you don't have that knowledge within your team, the way you would go about solving this problem is to look for a specialist consultant who can help you out with this work. In the area of intellectual property law and patents, this specialist consultant that you'll be looking for would be a patent attorney. Now, patent attorneys are fully qualified legal professionals who specialize in patent law. Patent attorneys are experts at navigating the patent application process and are experts at dealing with all matter of legal litigation relating to patents. They'll also be able to provide their clients with expert advice on how to claim the maximum commercial benefit from the ownership of a patent. Now, some of you out there might be thinking slightly cynical thoughts, might be thinking, but patent attorneys, well, they're lawyers, aren't they? Blood-sucking vampires who just want to take all my money. You know, that's a stereotypical view of a lawyer, isn't it? People like this, perhaps, okay? Well, whilst I can't speak for every single patent attorney on the planet, over my time, I've got to know quite a lot of patent attorneys. And I can certainly say that I haven't met a single patent attorney who is like this. All the patent attorneys I know are more this kind of people. Happy, cheerful, helpful people who just want to help people out. And if I can also say, perhaps slightly geeky, tech-loving individuals. And very much on the same wavelength as us engineers. And there is a reason for that. If you think about the heritage and the upbringing of people entering the patent attorney trade, well, we all come from the same roots. If you remember, I was able to enter the patent attorney trade on the back of my technical qualifications. And as Andrew also said, he did as well. This is absolutely the typical, normal path for patent attorneys entering the trade. They do this on the back of a technical qualification, not a legal qualification. So this means that patent attorneys are both fully qualified technical specialists and they're lawyers. So you enter the trade with your technical qualifications and then you undertake additional years of training to become a patent attorney. And this is your legal training. So when you are dealing with a patent attorney, what's very important to remember is that don't hold back with the technical details. Don't think, oh, they're lawyers, they're not going to understand what I'm talking about if I start using jargon. No. Remember where these people have come from. Okay? They will understand. They are technical specialists just as much as every engineer is. Remember that the more detail you can give a patent attorney, the better advice and the better service you can get from them. Now, the profession of patent attorneys is governed by a chartered institute. So us engineers, we have the IMechE. Patent attorneys have CIPA, the Chartered Institute of Patent Attorneys. And they have their headquarters, CIPA Hall, down in High Holborn. So not too far from one birdcage walk. And if you're looking for a patent attorney and not quite sure where to find one, well, CIPA is a great place to start. And you can see the web address there on the screen. Have a chat with them and they'll be happy to put you in touch with a patent attorney who will be more than happy to help you. So, what is a patent? Well, a patent is a form of intellectual property right, which assigns ownership of a specific technical invention to a specific person or organization. The theory being that this will prevent unauthorized copying and plagiarism of the invention. So for example, if we look here on the screen, we can see that this particular patent here, this is the front page of a patent document, and we can see that this patent document states that this particular invention, cyclonic separating apparatus, belongs to Dyson Technology Limited. And this patent is a legal document. And so there can now be no doubt about who owns this particular technology. It's there in a legal document in black and white. And the rights patent holder is written into and enforced by law. Okay, so it's a legal right. Now, the big benefit of patents is that it gives the patent holder a monopoly on working the invention in the patent document. So we're talking about things such as manufacturing the technology or selling the technology. Only the patent holder can do this. The patent holder can, however, give permission to a third party to work this, but this permission needs to be given by the patent holder. And this monopoly, which a patent grants, can last for up to 20 years. I say up to 20 years because at the end of every year in the life of a patent, the patent holder needs to pay a small fee to keep the patent alive. In the United Kingdom, we're talking hundreds of pounds, so we're not talking crazy money here, but this fee needs to be paid. If it is not paid, then the patent lapses and the monopoly is lost. And when a monopoly lapses, and I'm sure Andrew will tell me here, it's incredibly difficult to get it back again. So you've got to keep paying your fees. And you can pay this, and you can renew your patent up to 20 times, which brings us to our 20-year mark. If a third party violates the monopoly, infringes it, then there are statutory legal sanctions laid down in law and procedures which a patent holder can follow to seek reparations. And all of this is laid down in law, and the procedure will be backed by law courts. So when you're applying for patents, basically what you're trying to do is you're trying to cut a deal with the state. You are asking the state to grant you a monopoly on your invention, and the state will agree to give you this monopoly on two conditions. Firstly, the technology has to meet the requirements for patentability. We'll talk about that a bit later. But then you also need to write a detailed technical document fully describing your invention, and then to make this document freely available to the world. And even after a patent lapses, this document will still remain available in the public domain. Now, this document is clearly the patent document. And in today's 21st century world, these are really easy to get hold of. You can find them on the internet. Okay, so the big search engine and the one, if you like, the professional's choice would be a Spasnet, which is a search engine run by the European Patent Office. And the web address is there, and they've got patents going all the way back to the start of time. Okay, that is the big one. Google also has a patent search engine. The address for that is also on the screen there. But if I had to choose between the two, if I could only use one, I think I would only use a Spasnet. Maybe Andrew would agree with me on this one as well. If you're looking for rules relating to the way in which patent works and the regulations around patents, a great place to look would be the legal documents. In the United Kingdom, it is the Patents Act 1977, a link for which is on the screen. And if you're looking at European patents, it's the European Patent Convention, EPC 2000. Again, the link is on the screen there. And in fact, if you read these two documents, you will actually see that the way they read and their content is actually very similar. And there's a reason for that, and we'll get to that later. Also, when you read these documents, what is actually quite refreshing about these documents is that they're actually written in very plain English. Some of the legal statutes can be written in a very sort of flowery, legalistic language, but these two are actually written in very straight English, so they're easy to understand. You may also want to consult the Patent Cooperation Treaty, PCT document, which describes the way you can take a patent from one country and transport it to another. Now, this document, the Patents Act 1977, is not a new document. It has a very long history, and it has evolved over time to the form in which it is today. If you want to trace its history all the way back to the start, it will take you all the way back to the late 16th century, and our dear Virgin Queen, Elizabeth I. Elizabeth I was the first monarch in the United Kingdom to introduce the concept of granting state-enforced monopolies, or patents as they became known. Elizabeth I originally granted monopolies not necessarily for technical inventions, but for the trade of common commodities such as starch and salt. And all matters dealing with these monopolies were governed by the monarch. So the granting of monopolies and dealing with disputes was all done by the monarch. And particularly by 21st century standards, the way in which the patent system was run back then would have looked pretty corrupt, with favours being done for maybe whoever was the favourite of the Queen, or whoever could pay the monarch the most money. I guess that was the way it worked back then. And this was the status quo through the reign of Elizabeth I and her successor, James I. Roll on a few more decades through the reign of James I and into his successor, Charles I, and then we end up with a Statute of Monopolies in 1623. Now, this statute is significant because this is a statute which really lays the foundations for the patent system as we know it today. This statute also makes it pretty clear that they also didn't like the way Elizabeth I and James I managed the patent system, because the first thing it did was to revoke all their work. All the patents which were granted by Elizabeth I and James I were annulled, so the slate was wiped clean. They then went on to really rub salt in the wounds by taking away all the powers regarding patents from the monarch and redistributed them. So the power of granting monopolies was given to Parliament, and the powers of dealing with patent disputes was given to the law courts. This statute also introduced some new requirements for patentability. Okay, so this is really quite modern. So for example, there was a requirement for a requirement that only patents could be gained for inventions that were new. So a requirement for novelty. This is a requirement which still exists to this day. It also introduced the concept that patents had a maximum lifespan. Originally, this was 14 years, but over time, this has evolved to the 20 years which we have today. So, from small beginnings, okay, patents have grown in their power and stature in the world. Originally, patents were fairly fanciful things, nice things to have, but maybe not massively useful. Today, however, patents are highly powerful commercial legal tools which can really make or break a company's position in the commercial marketplace. The big advantage of patents in the 21st century world is that they allow for intangible technical ideas to be turned into physical possessions, which can be sold, rented, licensed, just like any physical thing, a car, land, building, anything like that. Remember that there is absolutely no requirement if you want to apply for patent for that technology to actually physically exist in the real world. You do not need to have a working prototype. All you need to have is a fully developed idea which you can write a detailed technical document on. So that's a very powerful thing indeed, turning ideas into assets. Now, because they're assets, well, you can declare them on balance sheets, just the same as you would anything that your company owns. There are sometimes financial benefits which are provided by the state for pursuing patents. So, for example, there might be tax reliefs given for technologies for which patents are being pursued. The idea being that the state wants to promote innovation in industry. Patents are also sometimes used as a metric of innovation, and they can be used to increase the share price of a company. So a potential investor might look at the activity of a company in the patent world. An investor might look at the patents which a company owns, but an investor might also look at the patents which a company is pursuing. So patents which a company has applied for and is looking to gain. The reason why a company might do this is because if a company is pursuing lots of patents, well, this is a sign that the company is doing stuff. It is generating ideas, it's innovating, it's generating intellectual property. And this clearly is something which an investor might want to get on board with. There's also a very 21st century use of patents, and this is to use patents to take strategic control of a marketplace through the tactical purchasing of intellectual property. Now, the way this works is best shown through a diagram. Okay, so this purple circle here, if you like, is the classical use of patents, where a company will take out patents and develop IP which directly protects the core product. And these are technologies which are actually being put out and sold. And so this is the classic use of patents. So a competitor can't make a company's core product or something very similar to it. Okay, so this is the classical use. Today, however, companies have also got into the practice of buying up or developing other technologies which are more or less related to the core product. Okay, and these are technologies which a company may never actually bring into reality. They just own the IP. So what this does is it puts up, if you like, a second barrier of protection around the core product. So the idea being that if a competitor wants to get in on this marketplace, the competitor now can't make the core product, but now equally can't make anything that is even remotely similar to this core product. Because if they try, they're going to fall under the realm of these satellite technologies. So this, of course, makes your core product look extra exclusive, so giving you a definite advantage in the marketplace. You have to remember there is absolutely no requirement for a company to actually carry out active trade with the technology described in a patent. All that matters is who owns the patent. And of course, if a competitor desperately does want to use one of these satellite technologies, well, you've got an advantage. You can always allow the competitor to use it, but for a fee, of course. Now, the next thing I want to talk about is the scope of a patent. And I think there's something which I really want to get off my chest, because it's a bit of a bugbear of mine. A number of times I've watched these entrepreneurial television shows, and a potential wannabe entrepreneur stands up and says, I've got a worldwide patent for my invention. And when I hear this, and I'm sure, Andrew, you'll agree with this, I die a little bit inside. My heart sinks, because I know that this guy is talking absolute rubbish. Because there is no such thing as an international patent. It is impossible to do this. It is impossible to get a single patent document which will grant you a monopoly over the entire globe, no matter what people say. It's not possible. A patent is a right which will only give you a monopoly in certain areas of the world. So a British patent will give you a monopoly in Britain. German patent will give you protection in Germany, Chinese patent in China, and so on and so forth. It is entirely possible to gain patent protection for the same technology simultaneously in different countries. Okay, but you have to be a bit careful about this because it can get expensive. Because then you're going to have to start employing multiple patent attorneys, pursuing multiple patent applications. You know, the costs just multiply. But the important thing is, it is impossible to get a patent document that covers the entire globe. Now, the closest thing that exists to a multinational patent is actually what we have in Europe, and that is the European patent. Now, each country in Europe has its own patent office. So Germany has one, France has one, United Kingdom has one, so on and so forth. And if you wanted to gain patent protection in multiple countries in Europe, one way you could go about it would be to put in an application to each of these patent offices individually. Now, this is quite an expensive way of doing things because each one of these applications costs money, and you would need to employ patent attorneys in each of these countries. So you're multiplying up your costs. Now, in Europe, there is a better way of doing things. You can apply for what is called a European patent. Now, in Europe, we have what's called the European Patent Office, which is, if you like, an umbrella organization which sits above and coordinates activities of all the patent offices in Europe. So when you apply for a European patent, you only pursue a single patent application. So only one patent attorney, only one patent application. And if it's granted, you end up with a European patent. Now, in a rare moment of multinational teamwork, all of the countries in Europe have managed to write and harmonize their laws regarding patent law, so that the requirements for patentability and the patent application process is the same in every single country in Europe. So this means that if you end up with a European patent, this technology will therefore meet the requirements for patentability in every single country in Europe. So you can transport this patent application to all the different countries in Europe. So when you receive your European patent, all fully granted, you also effectively receive a tick box form, and then you can select the countries in which you want to gain patent protection. The European Patent Office will then send your patent document off to these local patent offices, who will then receive it and go, aha, well, if it's good enough for the European Patent Office, it's good enough for us. It's in. And that's it. In one fell swoop, you have gained protection in many countries all at once. So notice that the patent application process to apply for European patent is broadly the same as if you're applying for a patent locally in the United Kingdom, which is why our laws read the same. So how do you actually go about applying for a patent? Well, the first thing you need to do to apply for a patent is to write a document describing your invention. This is your patent application document, and will form and will gradually evolve into your final patent document. And then you need to send this document off to whichever patent office you want to gain protection. So it might be the United Kingdom Intellectual Property Office, and they're down in Newport in South Wales, or the European Patent Office. Now, the date in which you submit your patent application is very important, because it sets in stone a particular date, which we call the priority date. The relevance of this will be made clear in a moment. And then after a period of time, the patent office will process your application and publish it. When your patent application is published, it will be made freely available, and you can find it on Espacenet. You can now put patent pending on your product. Your patent will then go through an examination phase, where the patent office will test it against the requirements for patentability, against what we call the prior art. And then you'll enter a phase of correspondence between the patent office and the patent applicant, where the patent office will write to the applicant, giving lots of reasons why the patent office thinks that the application does not meet the requirements for patentability. And then the applicant can then write back proposing corrections or giving counter arguments why the patent office has got it wrong. And then maybe you get 2 or 3 rounds of this, and then eventually at the end of it, the patent is either finally granted or it is point blank refused. Hopefully you get a granted patent, because then you can put patented on your technology and the monopoly will begin. Now, all of this takes a long time. In the patents world, things move at a glacial speed. And all of this can take up to 54 months, sometimes more, for this process to be completed. And yes, you did read that right, 54 months. That is 4.5 years. These things take time. The saving grace is that when a patent is granted, the monopoly is backdated to the date of which the patent is published. So if someone does an infringing act after your patent is published, then you can still sue them if your patent is granted at the end of it. Now, the requirements of patentability, well, there are 4 of them, and this is all laid down in law. Okay, so the 4 requirements are: 1, that the invention be new; 2, that it's involved an inventive step; number 3, be capable of industrial application; and 4, not lie within a list of exclusions. Okay, and we're going to talk about all 4 of them. So let's very quickly deal with requirements 3 and 4. Now, requirements 3 and 4 basically lay down the foundations of what kind of things you can get a patent for and what things you can't. So, for example, you can get, in order to be patentable, the technology has to be a genuine technical industrial thing. So you can't get a patent for a painting or a piece of music, because these are not industrial inventions. They're works of art, and so they're covered by copyright law. The law also introduces the concept that patents can only be granted for technologies which the state is willing to endorse, because effectively, by granting a monopoly, the state is endorsing the technology. So you can't get a patent for something which the state regards to be amoral. So you can't, for example, get a patent for, I don't know, something like a letter bomb or an IED, because the state regards that as being against morality. So that's those two done. Now let's look at the other two. Okay, let's start by looking at novelty. Okay, novelty, remember, is one of the earliest requirements for patentability, which was laid down in the Statute of Monopolies right back at the very start. Let's look at this one first. Well, the law states that to be patentable, an invention must be novel. The law then goes on to state that an invention is novel if it does not form part of the state-of-the-art at any time before the priority date, made available to the public by written or oral description, by use, or in any other way. Now, let's unpack this a bit, okay? Let's break it down. So, the law says that an invention is novel if it does not form part of the state-of-the-art, okay? So, it's not known. But this knowledge must be made available to the public. So, an invention is novel if it is not known in the public domain. And then the law also puts a time limit on this. At any point, at any time before the priority date. Now remember, the priority date, we spoke about this earlier, the priority date is the date at which you have submitted your documents to the patent office, okay? The date you have applied for your patent. So that date which you submit your documents to the patent office is very important because it draws the line in the sand, okay? So if you want to put this in other words, maybe sort of slightly more normal language, to be patentable, an invention must not be known anywhere in the public domain, anywhere in the world, before the date you have submitted your patent application. Now, this is quite an important concept because even some really obscure disclosure of your invention, perhaps in some really obscure magazine on some small South Pacific island, even that could be enough to destroy novelty in your invention and prevent you being able to gain a patent if this publication was published before you have applied for your patent. This will be before the priority date. If this publication is published after the priority date, after you've applied for your patent application, well then that's fine, okay? Because that will not destroy novelty because it is after the priority date. So before you apply for a patent, it's a good idea just to satisfy yourself that your invention is indeed novel. So have a look on the internet, read some magazines, look on Espacenet, see what you can find, and convince yourself that your invention is actually novel. This may save you a bit of cost, money, and heartache. Now, before the priority date, novelty kind of hangs in the balance. It's a volatile thing. It can be maintained, but it can also be lost. And sometimes the acts of you, the applicant, can actually go some way to destroy novelty. Okay, so before you've applied for your patent, there are some do's and don'ts and some things which you must do to try and maintain novelty in your invention. Let's look at some of these. Well, things you certainly should do is before you have applied for your patent, you should try your best to keep your invention a secret. Okay, because if your invention is a secret, there's no way that your technology can form part of the public domain. There's no way it can be known to the public because you've been very careful to keep it secret. You can, of course, carry out in-house testing, and of course, you can talk with your colleagues because this is all work and all conversations which has been carried on behind closed doors. It's not a public disclosure of information. It's all private conversations. If you do need to talk to third parties, such as suppliers or consultants, make sure that it is absolutely clear that these conversations are to be kept secret. Okay? Don't be afraid to ask these third parties to sign what we call non-disclosure agreements. Non-disclosure agreements are basically contracts which both parties sign where they agree that the contents of this discussion should be kept secret. And companies are generally pretty happy to sign them. They're not signing their lives away. They're just agreeing not to talk about something. And remember that after you've filed your patent application, you can say and do what you like, because nothing that you can do after you've filed your patent documents can jeopardize novelty, because the priority date is the date at which you file your patent application. Now, some things you definitely should not do before you file your patent application is to do anything that can disclose the technical concept in your invention. Even if you do this thing accidentally, it can still destroy novelty in your invention and so prevent you getting a patent. You can carry out public testing, but you have to do so very discreetly. Okay, so for example, a bit of case law. There are two manufacturers of portable movable traffic lights. I won't mention any company names, but you'll probably see them on the road blocking up your traffic on your way to work because of roadworks. Okay, we'll call them Company A and Company B. Both companies developed an improvement to their traffic light systems. No idea what this widget did, but they did. Okay, Company A took this advancement and put this added thing inside the casing of their traffic light, and then they tested their traffic light in public on the roads. So because the advancement was hidden within the casing of the traffic light, no one driving by would be any the wiser that this technology was there, and so novelty was maintained. Company B, however, developed something very similar, but instead mounted this extra widget on the outside of the traffic light in a little box on the surface. So now it was obvious to everyone driving by that there was something different going on here. And particularly someone who was skilled in the art of traffic lights would have a pretty good idea what was going on and how it worked. So this was enough to destroy novelty. So Company A could get a patent for the technology, but Company B couldn't. You should obviously also refrain from publishing documents describing key technical concepts in your invention, and obviously avoid having non-confidential chats with people about your technical concepts as well, because obviously this is going to be a public disclosure of the technology, and so you will lose your novelty. Now, it's very common, and I've had many people come to talk to me being so worried about this novelty thing. So, oh my goodness, I can't talk to anybody. What can I do? I can't talk to this person. I can't talk to that person. How can I ever develop my idea? What I would say to these people is time out, relax. Okay? Before you file your patent application, be cautious, yes, but also be sensible. Treat the technical information in your invention in much the same way as you would treat any other piece of sensitive personal information. So, for example, your bank account details. You wouldn't give your bank account details to just anybody. You might give these details to someone that you really trust. But if you needed to give this information to a third party who you didn't really know, you'll be looking for assurances that this third party would keep your information confidential and would treat it with sensitivity. It's exactly the same with the technical concepts in your invention. Okay, it's exactly the same. Remember that if you're not sure, you can always ask the third party to sign a non-disclosure agreement. And if you're really not sure, well, just don't say anything. It may be a conversation which you can have later. Remember that after you have filed your patent application, you can say what you like to anybody, because nothing that you can say after you filed your patent application can destroy novelty in your invention. So that's novelty. Okay, let's look at the last requirement for patentability, and that is inventive step. Now, inventive step is a bit of a harder test to pass than novelty. Novelty is quite a binary thing. Okay, an invention is either in the state of the art before the priority date, or it's not. You know, it's one or the other. Okay, inventive step, however, is less to do with the timing of the invention and more to do with the nature of the invention. It's a concept which it's a concept which is very much open to argument and debate, and it's why it's great fun arguing it out. And I think that's why patent attorneys love this, because it's a good chance to have some healthy debate in the legal realm. An invention, the law states that an invention is inventive if it is not obvious to a person skilled in the art, having regard to the prior art before the priority date, to make the invention. So effectively, what this requirement is that in order to be patentable, an invention needs to be a non-obvious development of the technology. The technology, which is being described in the patent application, has to move the technology on in some non-obvious way from where it was to start with to the point where the technology is taking it. And that step must be something which is a non-obvious development of the technology. There needs to be some element of, how should we say, magic, inventiveness, human ingenuity, which has made that leap possible. Now, the test for inventiveness is done through the eyes of a fictional character called the person skilled in the art. Now, I don't know whether you know, but in law there is a whole cast of fictional characters which are used as yardsticks to justify whether a legal test is passed or failed. And in intellectual property law, in patents, it is the person skilled in the art. So, who is this person skilled in the art, you ask? Well, basically, he's a massive geek. Okay? He's a great person to have on a quiz team, but only for one round, because he knows absolutely everything but about one topic and one topic only, and knows absolutely nothing about anything else. The person skilled in the art has some knowledge of the common tools of the trade, such as maths and basic physics, can solve simple problems and can follow some basic instructions. But here's the big caveat: person skilled in the art doesn't have one single iota of creativity or imagination. And remember, person skilled in the art also doesn't know anything outside of his realm of expertise. So when it comes down to arguments regarding inventive step, a key element to it is often deciding what the person skilled in the art knows, and that generally unlocks the inventive step debate. Let's look at an example of how it works, because I can try explaining how this works. It's better to show it using an example. And let's think about a bit of an artificial example, but I think a good one nevertheless. Let's think about Thomas Edison back in 1879, and let's imagine that modern 21st century patent law was in effect back in 1879. And we're also going to think about the state of the art being back in 1879, because that is the priority date. Okay, so Thomas Edison has applied for his patent back in 1879. Now, Thomas Edison, what he did was he discovered that putting a glowing filament in an inert gas environment prolonged the life of the filament, and so we get the light bulb as we know it today. So the question is, would he have got his patent? Is his invention novel, and is it inventive? Well, let's start by looking at the facts of the case. What is known in the state of the art? Well, in the state of the art, it is well known that passing electricity along a wire will make it glow, but then it will burn out quickly. This is known. We also know that chemistry experiments have shown that combustion can be prolonged by immersing a burning object in an inert gas. This is what we know. So firstly, is his invention novel? Well, no one has ever made a device such as Edison's light bulb. No one has ever tried putting a glowing filament in an inert gas environment. It doesn't exist. So easy. It's novel. That test is passed very quickly. Easy peasy. But what about inventiveness? Well, we need to think about the technical concepts. Now, the automatic knee-jerk reaction would be to say, well, hang on a minute. Well, we know about the electricity making something glow concept. That's great. So it's going to get hot, okay? And we also know that hot things in inert gas don't burn out quickly. Everything's known. It must be obvious, right? That would be the knee-jerk reaction. But stop. Slow down. Think about it. Think about what the person skilled in the art would know. Let's think about it in the eyes of a patent attorney looking at this. If you think about the first concept, the passing electricity along a wire. Well, this is a technology which resides in the realm of electrical engineering. So a person skilled in the art knowing about this would be a person skilled in the art of electrical engineering. If you think about the second point, the burning object in the inert gas concept. Well, this is a concept which resides in the realm of chemistry. So someone knowing about this will be a person skilled in the art of chemistry. Now, if we think about the legal definition of the person skilled in the art, well, would a person skilled in the art of electrical engineering have any awareness of chemistry? Well, by the definition of the person skilled in the art, the answer would be no. Remember, the person skilled in the art knows about his area and nothing else. So it would not be obvious for a person skilled in the art of electrical engineering to look to the world of chemistry. Similarly, we could go the other way as well. Would a person skilled in the art of chemistry have the awareness to look to the world of electrical engineering for an application of this technology? Well, again, the answer is no, because the person skilled in chemistry knows about chemistry and nothing else. So, thinking it out this way, we can say that Thomas Edison's light bulb is inventive, because it would not be obvious for a person skilled in the art of electrical engineering to look to a chemical solution to the problem, and vice versa. So, it is novel and it is inventive. Thomas Edison, you can have your patent. So there we have it. That is all 4 requirements for patentability covered. That is all I've got to say today. Thank you very much indeed for listening. We will now field any questions. Thank you very much for listening.
Thank you, Robert. Very interesting presentation. Just a reminder, please, if you have any questions, type them down in the Q&A box. I've got a couple of questions to start with. There are 2 in the same topic. After Brexit, if one files a patent in the UK, will it still be covered for Europe?
Andrew, do you want to take this one?
Yeah, sure. You might remember the slide that Robert put up with the map of Europe, and also the comments before. There was a slide, I think, just before that that talked about British and German patents and so on. If you've just got a UK patent, I mean, I should take a step back. Brexit has no effect at all on the European patent system. None of the treaties are EU treaties. And in fact, the European patent system has about half a dozen non-EU states in it already, including Switzerland and Norway. So the Brexit question doesn't have any effect on what Robert's just talked about. If you've just got a UK patent, it doesn't cover Europe now, other than the UK bit of it, and it won't cover it post-Brexit either.
Okay, good, thanks. The second question we have here is from Ankur. Are we able to move a patent application from the IPO to the EPO if we have applied to the IPO but not started the research stage?
I think that's one for me as well. I'm going to give an "it depends" answer, and this is where the format falls down because I need a supplementary question, and maybe Anchor can type that in while I'm talking. It depends how long ago you filed the application. You say that, and I'm assuming by IPO we're talking about the UK IPO here, and I say that because the time limits are different in different offices. If you're not at the search stage yet, that suggests, given that the search is required to be filed within 12 months from filing, that your question relates to an application filed less than 12 months ago. In which case, yes, you can. You would simply file at the European office, and Robert briefly mentioned a priority date. And this is a concept where you can file in one country, and then you can deal with your foreign filings up to 12 months later using a thing called the Paris Convention, which establishes a date of filing for your first filing, a priority date, which you can then apply to later filings in other countries, as long as they're filed within 12 months. So to answer the question, can you move your UK application into the European Patent Office? Yes, if you're still in the first 12 months. After that, you can't. And it's a question that comes up occasionally. When the convention setting up the European Patent Office was written, there was an article put in at the end, Article 135, for those that really want something to do rather than go to sleep or something. And it was put in, this thing was drafted in the late 70s. As Robert said, it's one of the few successful and was one of the first regional patent systems. And there was an idea that people might want to go backwards and forwards because they didn't like it. So this article was put in to allow a thing called conversion, but it required implementation in the national law, for example, of the UK, which wasn't done. So on a simple reading of the European law, it looks like you can flick backwards and forwards. In practice, you can't, because none of the national parliaments introduced law to allow their side of that to happen.
Okay, Thank you, Andrew. Got a question from Simon. Is it possible to extend the patent?
Me again? I'm looking at Robert's very small thumbnail face. I'm guessing we're talking about time rather than territory here, in which case there is a thing called a supplementary protection certificate, but that really only applies in the pharmaceutical field and is designed to allow an extension to make up for the time you might spend getting regulatory approval for a drug. It doesn't really apply in our field of sort of engineering. So the answer is more or less no. On the other hand, it's quite normal practice if you've got an ongoing development program, you've got feedback from customers, you've got warranty issues, you're improving the product, you might well file further patent applications with later dates. And that plays into what Rob was talking about in terms of inventiveness and also disclosure. So you need to have something that is inventive over what you've already sold and already published in your earlier patent applications. But if you've got an ongoing development program, it would be very normal to have a parallel ongoing patent filing program. And of course, the later date then restarts your 20-year clock. So as long as there's development going on, in principle, yes, you can extend by protecting the newer, interesting bits that you're building into the product as you go along.
Okay, thank you, Andrew. A question from me, actually, sort of in today's world where there is a lot of technological advancements, primarily in the IT sector, and they're going very quickly. And people tend to make the money by bringing that product very quickly into the market. Is it still a benefit of filing a patent?
Rob, or shall I take that?
Well, I think, well, definitely there is an advantage because you still gain protection from the moment you file your patent application, I believe, because then you set your priority date. Andrew,
yes, that's right. I suppose maybe a circumstance that you wouldn't is not so much that it's a fast-moving, fast-developing market, but maybe if you've got a very, very short life product, that might be a situation in which you might not, because these things take a few years to get granted. And as Rob said earlier, you can get retrospective protection, but if the market's already moved on so far beyond your product and there's perhaps a very small window of infringing sales against you, I mean, it's worth pointing out that, patents have all sorts of uses, tax reliefs and defensive portfolios. But if here we're talking about the offensive suing infringers thing, it's very rarely commercially sensible to do that for the money. The damages are normally not enough recompense for all the management time and just general cost of litigation. So litigation is usually done for injunctive relief. In other words, a court order to stop your competitor operating. And that can include all sorts of interesting disruptive things like stopping stuff at port of entry, seizing goods, having them destroyed, court orders. Apple is a really interesting case here where the British courts ordered Apple to put a website notice on their website admitting infringement of Samsung's rights. Apple actually didn't comply with the order, and for a while any senior Apple employees coming to the UK were likely to get stopped and taken off in handcuffs, which is all good fun. So it's usually the court orders you're interested in with any infringement actions rather than the money. So there's not much point doing it if the horse is already bolted. If you've got a very short-term product, retrospective money is kind of handy, but what you really want to do is stop your competitor in the middle of selling. It's good reputational damage. It can get them into penalty clauses and all sorts of things. So it can be quite a powerful commercial action at that point, but not usually later.
And I think I can also add that if the usefulness of an invention, if you do have a granted patent and the usefulness of the invention, it lapses, so it ceases to be useful. Remember, you've got to pay to refresh your patent every year.
Yeah.
And it can last for up to 20 years if the course If the lifespan, the course of this invention has run, it is absolutely normal for a patent applicant or a patent holder in this case now, isn't it, to just naturally let the patent lapse and not pay the renewal fees. Because there's no point paying money for something which is not useful anymore, and that's absolutely normal thing to do as well. And so that is before the 20 years is up. Just let the patent lapse.
Just one quick supplementary point on that. If you've got a fast-moving market, but people are prepared to sell the older product cheaply on low margins, then you might have a strategy where you put patent protection on the current product as you're going through, and then you might license the sort of second-tier people or even sell the rights and get a further sort of back-end revenue sort of income from an older patent. So it sort of depends, I guess, is the answer to that question. One of the interesting things about patents, and certainly the modern approach, is there's lots of strategy around it, and it's rarely about suing your competitors. Licensing, cross-licensing, leveraging negotiations, protecting yourself from an aggressor by saying, okay, we might have done something against your IP rights, but actually over here you're doing something against ours, let's talk. All those sorts of things play into a modern IP strategy.
Okay, thank you. It doesn't appear we have got any more questions, and it's nearly 6:15. If there are no any other questions,
I can just see one. It's about searching. Do we want to take that from Douglas Rawlings? Have you got that there?
No, I haven't.
Okay, I can just see it. So it's any guidance on how best to perform a search. How does one know how to look for cyclonic separator? Okay, it's a note I made. You'll probably remember Rob's slide about ISPASnet, and I was busy nodding saying, yes, it's far better than Google Patents. And that's not me being all terribly sort of anti-American in any way at all. The big difference between those search engines is that ISPASnet has far more sophisticated search tools. And when you're looking at that, you'll see a thing called the EPC or the IPC or the UPC. The PC bit of those is patent classification, and that's either international, European, or universal. They're more or less the same, but it's a very detailed hierarchical searching tree. And the question says, if I'm trying to invent a vacuum cleaner, how does one know to look for cyclonic separator? Well, the answer is if you use those classification systems, you don't need to, because you don't have to rely on a keyword search. And all that Google offers is a keyword search. Or at least there are ways of doing it with Google, but it's far easier on ISPASnet. And so the answer would be you might find perhaps that slide that Rob put up from Dyson. You look at the top of that. I don't know whether Rob can flash that up actually, whether you can find it, and because it had the front page of the patent specification, and you will see that it has these. It's a bit small, isn't it? But if you look. My cursor onto it, which is no good. But you see where the black line, top black horizontal line is, the text just above that. I don't know whether Rob can get his cursor on it.
Yeah. So we're a little bit this one here, isn't it?
It's the classification. Yeah, I can't see your mouse on mine, so I guess the audience can't. But yeah, on the black horizontal line, it's the patent classification. And if you feed that back into the search engine, having found something relevant, it won't be relying on keyword searches anymore. It will spew out all the stuff in the same technical field. And it's a very narrow classification, so it's actually very accurately classified. So patent documents are a really well-indexed body of technical material. Hopefully that helps Douglas. Use ISPASnet and use the patent classifications would be the answer. And try and get away from a keyword search.
Okay. I've got a question here, or two questions from Natasha. What made you want to pursue a career as a patent attorney? Would you suggest that getting a chartership in engineering first helps with this?
Well, we've both gone there, me and Rob. Yep. I would make one point on that last bit of the question. Would being a chartered engineer help? Well, in the UK, it is essential to have an engineering or science first degree. So not necessarily being chartered, but you as a prerequisite for taking the professional law exams, you have to have a technology background. There are sort of legacy ways of doing it with enough experience, but it's a lot of experience now. It's a very unusual route in. And Rob mentioned at the beginning, you know, don't be nervous about patent attorneys. It's not true of every country, but certainly chartered UK patent attorneys, they all have some technical background, and so it's one of the strengths of the UK profession that they can talk on even terms with the inventors and the technical development teams and all that kind of thing. So it is really useful. If you want to get chartered as an engineer, that would certainly make you a really good quality engineer, and therefore a really good basis to be a very accessible, very quick to understand new inventions type of patent attorney. So yeah, that would be my take on that question. Rob, what do you think?
Well, one thing I definitely find when I was working as a patent attorney is you got exposed to a lot of different inventions. It was absolutely fascinating. You'd have people coming in to talk to you. You'd have patent applications landing on your desk describing everything under the sun. You never knew quite what was going to happen. It was wonderfully unpredictable. So it was lovely to be exposed and learn about lots of different types of technology. You know, the fact that you need to have your technical background and then learn the law. You know, I think that comes from the concept that it's much easier to take an engineer who understands the whole world of science and is knowledgeable in the world of science and learn the essential parts of law for patents. It's much easier to do that than to take an expert lawyer and teach them the world of science, because you're never quite sure what's gonna land on your desk, and you need to be able to understand it fairly quickly.
Yeah, I see we've got a late rush of questions. Have we got time to take those? I see
yeah, absolutely, yeah. The questions just coming through.
Fantastic. Can you see them as well, Rob?
No,
there is one here by Belayet. What advice would you give to someone who have ideas but are discouraged by the thought that it has been done before?
Okay. Think about the geeky nerd. You know, the level of inventive step is actually quite low. So if it's completely been done before, as Rob said, you know, like the I'm trying to think back to the light bulb example you used, but if it's the whole product, all the nuances of it is out there, then forget it. You're not going to pass the novelty test. But if you're different, then it's about whether it's inventive, and the standard of that is relatively low. Certainly in the mechanical field, if you want to analyze everything, it's generally all levers or thermodynamics or you know, but you don't go down to that level. If you've got I have a client that does aerospace fasteners, and all the developments there are in cold forging and pulling and rolling and annealing and that kind of thing. We all know about those principles, or at least we learnt about them in our studies. But the clever stuff is in how those are put together and the shapes and the various processes. And they get plenty of patents, and they're not rubbish patents. They get products that blow the rest of the competition away, and they use patents to charge a high margin for them. That particular business. And on the face of it, you might say it's all been done before, but actually at the very detailed level, it hasn't. They get quite narrow patents as a result, but commercially they're very valuable because they protect their really quite interesting but narrow innovations. So I wouldn't be discouraged. If you've genuinely got something new that can make money in the market, you've probably, I say this with caution, as long as it's technical, you've probably got something patentable.
Okay, there are two more questions here. I guess they are related. Maybe you can address them at the same time. The one is, in regard to territories, would you have to apply to different territories, or will it cover all the territories? And the other one, which I think is related, is, can you file a patent without an attorney?
Well, certainly, I'll answer the first one, and the answer is yes, you can. It depends where you're filing. Generally speaking, an applicant has a right to file themselves. And if you're applying on behalf of a company and you have an internal authorization as an employee, you can generally do everything you want to in front of a patent office. If you're acting as an agent for someone else, in other words, setting yourself out as a sort of patent attorney for third parties, then you begin to get in quite a lot of difficulty with most patent offices. So it's a bit of a mixed bag. Perhaps I have an axe to grind in this. In fact, I certainly have an axe to grind in this. So hard for me to give a straight answer. If I were on the other side of the fence, I wouldn't file a patent without a patent attorney, because you won't know until you need it that it's not good enough, and they're rather expensive to just do a sort of half-hearted job on them.
The one thing about patents, and I didn't cover it in the presentation, but if you start looking through the pages of a patent, writing a patent is a real art. It's not an easy thing to do. It's very easy to do, but do it badly. But certainly when you start looking at the claims, if you like, legal clauses, so there's a section at the back of the patent, every patent document, which is the claims. And the wording of those, it's very clever, very precise. This is where it is a real art to write these. And these claims are where you describe in legal terms what the invention is that you are protecting. And the wording of those, the way they are structured, there is a lot of skill and a lot of know-how needed to do that well. And without years of experience and training to be a patent attorney, it's unlikely that someone can just come in off the streets and just do that automatically. It's something which definitely needs a large amount of training and experience to do well.
There's a couple of bits I would add to that. It's not just the precision of the language, but also once you file the patent application, you can't add new things into it. And so you're crystal ball gazing a lot of the time. And also you have to structure it. There's lots of restrictions on the way you're allowed to adjust it before you get it granted. And so you're sort of shooting into the dark against what patent objections the patent offices may put before you. And so you need to put in lots of good quality fallback positions. So there's a lot of prediction and guessing what the document might face, and you're very restricted on how you can maneuver to overcome those problems. And so there are, as Rob says, a lot of ways of writing the thing badly. And also the patent office's job is it is to prevent you getting patents. It's not to help you get good ones or broad ones. So you can get a patent that might actually have a fatal flaw in it. And as I said just now, you won't know until it really matters. You go and assert it, or you want to license it, and all of a sudden you find out there's a big problem with it, and you can't fix it at that point. It has to be built in at the point you file it. So those are the risks. But yes, in principle, you can, in some circumstances, do it without assistance.
We've got a follow-on question here from Neil. What would be the typical cost of establishing a patent, and would you need an annual maintenance cost?
Yeah.
Maintaining.
Yeah. Probably one for me then, and it feeds into that territorial question, which I'm conscious I neither has answered. The cost, of course, scales by how many territories you put a patent application and get it granted in. To answer the question from the back end, yes, you have maintenance fees. Most countries, those are annual. In probably 2/3 of territories, you don't pay them until the patent's granted. Unfortunately, the European system is an exception to that, where you actually pay them while it's pending. And the US has a completely different system where it's 3.5, 7.5, 11.5, and I forget the next one or two, but a really odd set of years for renewal fees. So they're not annual, but every government body takes a fee to keep the rights in force. So in terms of costs, as Rob said, there are no worldwide patents. You have to file in each territory. If you're a pharmaceutical company where you've got big volume, big margin sales in most territories, you might economically be able to justify filing in lots of countries. And generally, costs of patent portfolios tend to be quoted on the basis of that sort of portfolio, and that could cost hundreds of thousands of pounds per invention. For everybody else in the sort of mechanical, electrical, general fields, you might be absolutely satisfied with something that covers the US, Germany, UK, and France, and maybe a bit of Japan and maybe China or something like that. And I say that because if you've got rights in those countries, you've probably got the main selling markets for your product, and you can control that, and you've got the main manufacturing markets, so you can control copycat products as well at source. And so once you've got those main markets sewn up, you may find that the remaining markets simply aren't worth having for a competitor. That's the general strategy. So you wouldn't file across the world. And to answer the question on costs, depends a bit what field you're in. For a relatively simple mechanical device, you might be looking at, say, 3,000 to 5,000 to put a UK patent on file, so to draft it and file it and pay some search fees and get a report back from the examiner, and maybe 2,000 or 3,000 more to take that through to grant, and then a few £100 a year to pay renewal fees. So those are the sorts of fees, but you will end up paying those sorts of fees across several countries to get proper protection. It's a rare client these days that only is interested in the UK or even just the European market, particularly when you think about whether there are licensing opportunities. You may have a business that has no interest in operating in Japan, for example, but there might be a distributor and a wholesaler and a manufacturer who would love to. And if you've got a patent there, you can take a licensing revenue from them and allow them to do that. So territories matter, and the cost scales with territory. But a typical portfolio for a mechanical invention might cost you £20,000 or £30,000 to get really good protection around the world, and might cost you a few £1,000s a year, maybe say £5,000 a year, to keep that in force. And if you're not making £5,000 revenue a year off it, then I think you need a new product. So the maintenance fees, it's important to not focus too much on the cost of obtaining them, because in a mature portfolio where you've got your 20-year stuff and you've got some new stuff coming in at the front end, the balance might well be something like 2/3 of your cost is maintaining the portfolio, and only 1/3 is obtaining the patent in the first place. So it is important to think about renewal fees, but that would be a very mature portfolio where you've got far more patents already owned and granted than you're actually putting in at the front end. But with appropriate choices of territories, you can actually get quite a cost-effective patent portfolio, and very careful pruning of older portfolios, which might be by allowing them to lapse or selling them or licensing them, because the real cost build if you keep an old legacy portfolio that you're not really keeping on top of, with old products that don't make any money being covered. And so costs of filing, it's relevant, but actually the renewal fees are the thing to look at if you're an IP manager or something.
Okay, we'll go one last question here from Ben. If someone infringes your patent, how long after discovering the breach can you leave it before you claim breach of patent? And can you backdate the claim to when it was breached?
Mm-hmm. Yeah. Most countries have a statute of limitations like the UK does. So that's something governed by national law. In the UK, you can go back 6 years. And it's governed by each individual infringement. So let's say you've got somebody who's repeatedly selling something, you might find that their early sales are out of the 6-year window, but the later ones are. So you get them for the last 6 years. It's not that once they start infringing, you lose the ability to sue. More or less, there is a concept, at least in common law, of acquiescence, where if you ignore someone, you can be deemed to be saying, yeah, it's okay, I don't mind if you infringe. It's extraordinarily hard to use that as a defense, but it is there in theory at least. So broadly speaking, 6 years.
Okay. I think it's nearly now 6:30. So I would like to thank you both for the interesting presentation and discussion. And thanks all the participants for filing their various questions participating in today's event. And apologies if there were a few questions which we are not able to answer them all.
Yeah, I just want to say there are some interesting ones there. I mean, if people are interested, I don't know how Rob or Thanos feel about this, but if you've got a burning question, you could email it to me or Rob, and we might give you a quick reply on email.
Yeah, absolutely. No, that's a good idea. Great idea.
Great.
Okay. Thank you very much, all.
Okay, thank you. Okay.
Thanks, everybody. Thank you.
Bye.
Bye.